start and then we'll close the door.
Judge Millett, may I open court?
Yes, please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1092, Kimberly Springsteen-Abbott, petitioner versus Securities and Exchange Commission. Mr. Dre for the petitioner, Mr. Starzelski for the respondent.
Mr. Dre, you can start.
Good morning, and may it please the court. I'm Dominic Dre, and I represent the petitioner, Kimberly Springsteen-Abbott. This case is about 3 due process violations and 2 unlawful sanctions. The former includes sanctions imposed for unproven charges, inadequate notice of allegations, and unconstitutionally appointed regulators. The result is a lifetime ban, which this court has described as the securities industry equivalent of capital punishment for a woman who consistently under-reimbursed herself 10%, donated over $2 million to the funds that are in question, acknowledged misallocations when presented with evidence, adopted a new accounting procedure that FINRA and the SEC have inspected since without any objections, and who has reallocated all of the money that was in question. In fact, once you peel away the continuing education expenses, which were legitimate business expenses under the operating agreements, all that remains in this case that's actually been proven are 26 random and inadvertent personal expenses, which gets us to the first of the due process violations here. And that is
where did you raise those due process arguments before the SEC? You agree that you did not raise them there?
No, ma'am. So a couple of things on that. I was surprised to see the waiver argument. As we point out in our reply brief at page 5, there are numerous points where we raised due process arguments throughout this litigation. The SEC itself, by the way—
Where did you raise, can you tell me the page number of your brief to SEC where you raised these specific arguments that you just articulated to us?
I believe it's actually cited on page 5.
No, I'm sorry, of your brief to the SEC.
Yes, Your Honor. JA 73, 80, and 82. And I might add that the SEC knew that this is what it was reviewing, because at page 9 of the order that we're talking about—
Slow down here for a second. Sorry, I want to make sure I'm on the same page as you. Sorry, what pages did you say this you're talking about? Because I don't have the right numbers on my appendix to go up as high as you're going.
Well, 73, 80, and 82.
Okay. I thought you were saying 7380 was the number. That's my fault.
Oh, no.
I don't have a 7,000.
Yeah, no, that would be a surprise to all of us.
Yes, thank you.
And at those points, I can just read you the quote, Judge Millett. Perhaps that would be helpful. At those pages, we point out that FINRA violated the norms for assessing credibility, applied a double standard with respect to accounting.
So, Mr. Dre, though, can you point to where you've raised the constitutional due process claims rather than claims about due process under FINRA's, various statutory requirements?
Isn't the language of the statute fair process? Fair? I seem to recall, now that may be somewhat different from constitutional due process.
Yeah, so as we explained in the brief, the statute calls for fair process. That's in H2. And throughout, we asked for due process. I mean, for example, again, I'm just reading these off of page 5 of the reply brief. At 247, she says that FINRA hearing panel deprived her of due process rights.
Hang on, sorry. JA 247. I just want to pin this down because when I looked, I did not see the constitutional arguments you're voicing now in what you hear. So you say on 247, which one are you pointing to?
247, the quote is—
okay. Well, that's just, is this your notice? What is this? Is this a notice of appeal? Yeah, this is a notice of appeal. This isn't a brief. You have a lot of things on this notice of appeal you never briefed to the SEC. So where I'd like, if you could point me to the brief to the SEC where you raised that it was unconstitutional, your first argument to us, to treat a schedule of expenses listing allegedly wrongful expenses as evidence. Where is that one in your SEC brief?
Perhaps 203, JA 203 would be more satisfactory, in which she insists upon the protection of due process rights. That's the appellant's memorandum.
Let's see, sorry, where are you talking?
203, JA 203.
I'm on that page, sorry, which paragraph, just to make it go faster?
I'm sorry, I don't know the exact paragraph, Your Honor, but I think in the meantime, I can respond to Judge Silberman's question, which is the SEC itself argues that this is sort of beside the point because under cases like Cody, which is a First Circuit decision, they treat the due process guarantee under the Constitution and under the statute as comparable. And so even if the court construed this only as raising statutory procedural rights, they should be treated in pari materia with the due process rights under the Constitution. And moreover, all of this is still arbitrary.
Again, I'm still on page 203, although I also want to make sure you answer Judge Rao's earlier question. I don't see on page, I see a general line, a sentence that says the SD rules, I don't know what SD stands for, insist upon the protection of due process rights and do not provide for SD of someone who has not had their day in court beyond a reasonable doubt standard. But that's not what you've argued to us. So am I missing, is there something here where you're actually making the arguments you've made to us?
So the argument there encompasses due process rights, which—
Well, but that's not enough to raise it. Just say due process rights. You're making arguments to us that we have to make sure as a matter of jurisdiction that you actually raised, and just saying to the SEC due process is way too vague.
Well, of course, and so then we have, and this is the original string cite that I gave Your Honor, where it's 73, 80, and 82. She explains in greater detail that FINRA violated the norms for assessing credibility, applied a double standard with respect to errors, and treated proof of one item as establishing the impropriety of every item on the list. And that's what gets us to the pattern of practice.
The SEC did that, or you said FINRA did that?
FINRA did that, and the SEC did the same thing.
But then there was a remand to FINRA, and it had to then actually narrow down that list. But before we go on, Judge Rao, did you get your question answered about these pages?
Yeah, I mean, I guess I don't see anything that you're pointing to in the record that mentions the constitutional claim. So I guess if we assumed that those constitutional claims were not exhausted, have you presented reasonable grounds for us to consider them here on appeal, assuming that they were not exhausted?
Yes, Your Honor. As we explained, it is a very lax standard for reasonable grounds. This court's opinion in Action for Children's Television says that it is unnecessary to present arguments when an agency's general views are known. When it comes to most of these issues, that's more than satisfied. And I might add that even
well,
here—
before you add that, you said there's the statute already requires fair procedure, and to the extent the SEC treats that as equivalent, or certainly including the constitutional minimum of due process, we, before we could even decide the constitutional issue, as a matter of constitutional avoidance, would have to decide if the statute was violated. So we're back to looking again for where you made the same arguments you're making to us now as statutory arguments, which the SEC, of course, is qualified to decide. So where did you—
I would, Your Honor, I'm going to endeavor to reserve the balance of my time, I'm afraid.
Don't worry about that. Don't worry about that. We'll give you some time for rebuttal, but we're going to try and at least, I think,
it's the same. I mean,
trying to understand where this was actually preserved.
Of course. And I'm trying to situate it within this case as a whole. So I have given you the best citations that I have for that. They're on page 5.
Counsel, isn't your point really that the statutory demand for fair process is not substantively different than due process? So let's assume you didn't raise a constitutional due process. As the First Circuit had pointed out, fair process is virtually the same. But in any event, why is there not fair process? You could clearly raise that.
Yes, Your Honor, and that is why I cited the Cody opinion. So I'll be as quick as possible with these points. There are, as I said, 3 due process violations at issue here. The first are the sanctions.
Why don't you use the term fair process so that we don't
fair process it is. There are 3 fair process violations here. One is the change between, as Judge Millett pointed out, this case was before the SEC in 2017. They found that there was not enough evidence or no evidence for almost all of the 1,840 allegations. So they remanded it. They found at that time in 2017 that there had not been a showing of a pattern or practice. On remand and without a new hearing, FINRA simply declared that there was a pattern or practice. But if you look at the actual evidence in this case, and we've done our very best to make this as easy as possible, they don't identify the pattern that would be at issue. So there are examples of patterns and practices in this case. For example, the 10% under reimbursement that Ms. Springsteen-Abbott always made for herself.
This sounds like a sufficiency of evidence argument. This doesn't sound like a due process argument.
No, because what we needed was the reopening. I'm pointing out the arbitrary and capriciousness of finding a pattern of practice where there is not.
I know that sounds like a sufficiency of evidence argument. That's not a due process argument.
Why couldn't they rely on the record in the first instance? They didn't have to open up again as a matter of fair process if the prior record was adequate.
If it was, and it is not. And that's the whole point, is that the SEC, this is not correct. The SEC says in 2017, you haven't shown a pattern or practice. They send it back. There's no new evidence about a pattern or practice, and they just declare a pattern or practice. That's
hang on. They went through and proved, I forget, 80 or something particular things. Okay, 80 different times over the course of 3 different years. And then they concluded that 80 something times over the course of 3 different years is a pattern or practice. That's not one incident. I don't understand why you say the record didn't change. They proved exactly as you wanted, specific claims, not throwing in the other 1,000. And they did it over 3 years. I don't know how.
So the first thing in that is to subtract the 58 continuing education and other business.
No, we don't have to subtract those. That's a separate argument. As a matter that you may have a sufficiency argument. I'm trying to find your due process argument.
So the process point is
fair process, as Judge Silberman says.
Yeah, these allegations, she gets punished for 1,840 allegations that were not proven, or 1,700 some odd.
No, she doesn't. The SEC remanded and said you can't do that, FINRA. And so then FINRA came back and said, here's 80 something, and they occurred over the course of 3 different years.
And they made.
Wait, what's the problem with that?
The problem with that is that they got it half right. They reduced the fine and the disgorgement to match that reduced showing, but they didn't reduce the lifetime bar. That is an unfair process for her, and it departs from all the evidence.
Whenever you don't get what you want, it's an unfair process? Whenever you don't get the outcome you want?
Of course not. The failure here, though, is on remand, the numerical components, they adjusted by reducing the disgorgement and reducing the fine, but they never adjusted the lifetime ban.
Because they thought it was still appropriate for 80 something instances over the course of 3 years, combined with lying to investigators.
Again,
and engaging in what they found was bad faith.
So again, that is the fruit of the unfair process as well. The credibility determination was born of a process in which only at the hearing, it's JA 1033, Ms. Springsteen-Abbott objected to the inaccuracies in the expense schedule that she was given. At 1034, FINRA says, the Department of Enforcement says they'll have a new corrected schedule within a day or 2. They didn't present it until after the hearing and upon demand in a letter, this is JA 501 through 02, in which Ms. Springsteen-Abbott insisted on correct allegations against her. And even when that arrived, FINRA refused to reopen the record so that she could respond to the corrected schedule. So if you look at these things, and in fact, take the example of the children's meal that the commission cites in its brief. This is at page, I want to say it's 907 rather, where Ms. Springsteen-Abbott has an expense for a children's meal, and she has a bunch of expenses from the same restaurant. We know that. And they point out at the hearing that this was a children's meal, and she admits that she was on a diet and so forth after a somewhat embarrassing line of questioning. And then they give her evidence that this children's meal was actually not her, but rather her grandchildren. And then she immediately says on page 907, oh, then this was a mistake, and we'll reallocate it as soon as I get back to the office. Mm-hmm. That is the kind of opportunity she should have had to respond to the allegations against her. Instead,
she did have that exact opportunity, and she did respond in the hearing. And then she got caught when she said, oh no, repeatedly, that was my diet meal. She didn't say, I'm not sure, I don't remember. She said, no, I was on a diet at that time, and that's what I ate. And it was only when she got confronted with the email that she admitted that in fact it was for her grandchildren. So I don't understand what's the process problem there. She had every opportunity to respond during questioning, and she did. She just got caught.
The problem is that all of these things were extremely dubious because many of them were riddled with errors. And so she was doing her best to recreate the expenses after the fact. And
Counsel, it seems to me you are fighting over the evidence in the case. I'm listening carefully, and I don't hear a real process question, whether fair process or due process.
Well, then let me give you the third one, Your Honor, which is the unconstitutionally appointed adjudicators. This one concerns, and all three of them, again, are correct as under the APA's arbitrary capricious standard, as well as, of course,
for the appointments clause.
Excuse me. Would you go ahead, Naomi?
Oh, I was going to say my question to you about the appointments clause questions was, where did you exhaust those in the proceedings below?
So that one is not exhausted in the proceedings below. And as we explained, based on Freitag and this court's opinion in Koretsky, that does not have to be presented below.
So Freitag involved a non-jurisdictional exhaustion requirement. But here we have a jurisdictional exhaustion requirement. Doesn't that distinguish Freitag from this case?
No, it doesn't, because Freitag explains that the animating decision there is the judiciary's interest in protecting the separation of powers. It's not tethered to whether or not it was jurisdictional or mandatory or any of these other threshold issues. And in fact, I have an update on that because the two appointments clause cases that the SEC cites in response, Ganella and Maloof, we mentioned in the reply brief that those are the subject of a pending cert petition in Carr. The Supreme Court granted that a couple of weeks ago to take up the question of exhaustion in the ALJ context. Again, this is cited in our reply brief. It's the Carr case. It was granted on 11/9/2020, in which the court will take up this appointments clause preservation issue.
That's an SEC ALJ, right?
Yes, ma'am.
Yeah,
yes,
which is clearly a state actor, but you have to, the question is whether you exhausted the state actor argument when you're talking about FINRA. Right, and that is not something that the SEC has said. It said their SROs can be treated as state actors sometimes, and so it wouldn't have been futile to raise that issue before the SEC, and you may have even been able to wrap it into a fair procedure argument.
So again, Your Honor, I think that would be relevant, or that is a conversation we can have around some of the other claims, but that is not relevant for the appointments clause conversation because Freitag, Koretsky, and the PCAOB case, which explains that the probability of success, whether it's a non-frivolous claim or not, is relevant to the decision about whether ordinary preservation rules apply, and they do not. And PCAOB, if this court reaches the merits, disposes of this entirely, because that is...
So let me ask
you... Wait a minute, counsel. Elgin backed off the PCAOB case, didn't it?
Not in relevant part, Your Honor. The holding here is, it's principally at page 484 and 47 of that case where it explains the similarities in the double good cause removal, which applies to this entity.
Was your firm counsel before the commission?
We were at various times. There were other counsel as well.
So why wasn't the appointment clause issue raised before the commission? Why in Lord's name would anybody representing who you represent not raise the appointments clause issue, knowing that if you don't raise it before the commission, you're going to at least have a major problem in the Court of Appeals? I'm mystified as to why these cases come up all over the country, in which counsel hasn't raised the constitutional question before the agency.
They do come up all over the country, and I take your Honor's practice tip. I was not personally involved at that time. It's worth noting that Lucia versus SEC, which is also relevant to this case, was decided during the pendency of our case. I think that may contribute to the explanation.
Why? It didn't stop Lucia from raising it.
Well, Lucia didn't raise it in the first instance, and that case is somewhat unhelpful in its timing. Otherwise, I would rely on it much more in terms of preservation, because Lucia, the court just says timely and doesn't give many guidelines, which is part of why I think they took the Carr decision, took the Carr case just earlier last month.
So, Mr. Gray, is your position that for these types of structural constitutional claims that the exhaustion provision in the statute doesn't apply, or that raising of a structural constitutional question is reasonable grounds for us to reach the issue?
Well, I think that the Freitag case would frame it more in the latter structure, that it is the statute doesn't apply, because that wasn't construing this reasonable grounds exception in 78 CY1, I believe it is. But it's a belt and suspenders. In this case, we also have a statute that's very forgiving in terms of preservation. So reasonable grounds.
Can we read the statute to be forgiving? I mean, we have precedent saying that it is a jurisdictional exhaustion statute. If we just read reasonable grounds to be almost any question that we want to reach, then aren't we undermining the jurisdictional nature of the exhaustion requirement?
No, so this court also has precedent in the KPMG case insisting on nothing more than a reasonable explanation. And I believe it's also that case that distinguishes other examples like the extraordinary circumstances threshold that's required in different statutes, which I can't quote chapter and verse right now, but they're in our reply brief. This court has appropriately given credit to the way that Congress structured this preservation requirement. So no, it is a laxer standard than is written elsewhere. That's consistent with KPMG and other cases. And again, here, I point the court to the general views from Action for Children's Television. This agency's general views are already known, as we detail in the reply brief.
Can I ask another thing? You've argued that the FINRA hearing folks are state actors. Where have you argued that they are officers of the United, not just state actors, but officers of the United States, which is what you have to argue to make them subject to the appointments clause?
Well, we certainly argue that now, Your Honor, and that's the point. But
where have you argued that they're officers of the United States? That's going to require a complicated inquiry into the nature of this whole SEC.
Oh,
it's de novo review.
I understand the question.
They have to be, these FINRA hearing officers can't just be government officials. That's all state actor would mean if you had that argument. They have to be officers within the meaning of the Constitution.
I understand the question, and that answer is already provided by the Supreme Court in PCAOB. That's the whole point of that decision. They describe the similar removal process. Remember, it's the removal that's
not the removal process here. I'm asking about the nature of their decision-making role to be an officer of the United States. You have de novo review by the SEC in these cases. And so I did not see an argument in your brief that these are officers of the United States.
So too in PCAOB. I mean, that our argument on the merits of that is basically apply PCAOB.
You say you argue it now. Where are you arguing that they're officers of the United States as opposed to state actors?
Your Honor, the argument is that PCAOB is on all fours with this case, and as the court
You
explained,
have to show, you can't, I mean, that's a different scheme. This is a different statutory scheme that has de novo review by the SEC. And so you might be right, but normally we would expect someone to say they are officers of the United States. Here's the test for an officer of the United States, and apply the Peekaboo case that way. But I didn't see that argument. I just saw a leap from state actor to the assumption that the Appointments Clause applies. But if I missed it.
So I think we argue it. I think we point out that the Supreme Court's holding in that case explains at page 44 that PCAOB is modeled on the SROs, and at 487 they talk about 78 SH4 and explain that this is the exact same. These are birds of a feather in terms of how these two agencies are structured. So when the court reaches the merits of the Appointments Clause case, there's no room for doubt that that PCAOB applies in this instance.
In the Peekaboo case, there was a stipulation that the members of the PCAOB were officers.
I would have to look at that, but it's. I mean, if the court wants further briefing on whether or not they're officers, I'm happy to provide it. But
I'm just further. I'm trying to figure out if there's any. But go ahead.
Yes, but that's. I think it's stipulated because it's impossible to argue, to tell you the truth. I think the reason that PCAOB comes out that way is that given their decision-making capacity and the fact that these folks are double good cause removal away from the president is sufficient. And then, of course, that's just to get to the board members. When we're talking about the hearing officers, it's yet one further step removed, which leads to that great line about the Matryoshka doll of tenure protections. And that's where Lucia and others come into play.
Mr. Dre, say we were to agree that you have preserved these issues, and would we need to remand to the SEC to consider them in the first instance?
It would be I mean, the court certainly could. I think the better outcome would be to vacate the lifetime ban and the portion of the disgorgement that's attributable to continuing education and other business expenses. Set aside the 26 personal expenses, which, you know, Ms. Springsteen-Abbott has accepted responsibility for those from day one, in fact, during the hearing. But the court could, I think, adjust the disgorgement by, I think it's about $30,000. And then what really matters is vacate the lifetime ban and remand for consideration of that. Because under the guidelines, the SEC is to consider a bar for a number of years. I think it's up to 2 years for misuse of funds. This isn't even a conversion case like in Saad. And I'm happy to talk about Saad if the court is interested. But this isn't even a conversion case, which is a more stiff allegation. This is a misuse of funds case, and it involves no more than 26 items. So what I think would be the correct remedy, Judge Rao, would be to vacate the lifetime bar, and then we'll have to sort out whether, you know, some version of time served and expunging the bad actor scarlet letter that attaches under Rule 506D would be appropriate. But that's something that the commission could work out.
Great. Thank you. Do my colleagues have more questions?
No.
No.
Okay.
Thanks.
All right. I think we'll hear from the SEC now, but we'll give you a couple minutes on rebuttal.
Thank you.
Okay. We chewed up your time and more.
Hi, good morning. May it please the court, Daniel Staroselsky for the Securities and Exchange Commission. I would just like to make 2 points at the outset, one about the due process argument and the second about the Appointments Clause. With respect to due process, I think the court, Judge Silberman, Judge Millett, you have it exactly right. It doesn't matter what you call it, but everybody agrees that the proceeding has to be fair. And the commission addressed each and every argument that petitioner made before it to the effect that the proceeding was unfair. And that's why there was a remand to FINRA, both with respect to liability and the remedy. And so the order on review now is the commission's most recent order. It's not the FINRA's orders. With respect to With respect to the appointments clause.
But before we get to that, so they argue about the fact that the record was not reopened in the second round. Can you address that? What constraints there were on Ms. Springsteen-Abbott's ability to prove her case or not on the second round before FINRA?
Right, and first of all, I didn't understand them to be making this argument at all, either in their opening or reply briefs. This is something that popped up for the first time at oral argument today, but the commission addressed this issue at JA 12 to 13, and it said, first, against Judge Silberman's point, the remand order from FINRA to the commission the first time around, it didn't require FINRA to reopen the record. They could have, it left open to consider, the issues on the record that had been adduced so far. And with respect to reopening the record, I think the commission's point is that just petitioner didn't do enough to bring to FINRA's attention whatever issues that they wanted FINRA to consider. But that is all spelled out at JA 12 to 13. With respect to the appointments clause, just a couple of points. First of all, I think my friend might have misspoken. It's not the SEC's statutory scheme that's on review there. It's the Social Security Administration. And Judge Rao, to your point, that's an entirely different statutory scheme because as in FRATAG, there's no statutory exhaustion requirement. And it involves judicially developed exhaustion. And in that circumstance, if the courts develop an exhaustion requirement, they kind of have more leeway in determining whether it ought to be excused. But here we have a statutory exhaustion requirement, whether you call it jurisdictional, whether you call it claim processing, it's mandatory. We've raised the forfeiture point.
What do you think about the reasonable grounds argument, right? Is it reasonable for Springsteen-Abbott not to raise these questions, the constitutional questions before the commission, either because the commission lacks the power to decide them or has previously, declined to reach those questions?
Well, I think the courts have uniformly held that that's not a reasonable ground. I mean, I do want to take issue a little bit with the premise that the commission has a set policy on this issue. We cited the Quattrone and Ficken cases in our brief. Those involved a little bit different set of due process claims. The argument there, state actor claims, the argument there was that the way that FINRA and the commission had investigated certain conduct, they were acting jointly, and so that raised a due process concern. And in Quattrone, the commission actually dismissed the proceeding on that ground. But more fundamentally, I think the point is the reason you raise these arguments is that putting aside the label, you give the commission an opportunity to consider the arguments on the other side, and that informs this court's review.
Could the SEC decide the appointments clause issue?
I think the commission certainly could decide it. There's a question about remedy and so forth. But I think this court talked to that issue in the Jarkissi case that we cite in the brief. And the point is, especially with the appointments clause, Judge Millett talked about this. These issues get into the real minutia of how the agency or the body on review works, and regardless whether the commission ultimately has authority to remedy the decision, at a bare minimum, what it says will inform this court's review. And there's no shortage of these FINRA cases coming up through the pipeline. By my count, this is the third FINRA case just this term that this court is considering. And look, the petitioner's opening brief talks at length about how these issues have been written about for a very long time now. There was no obstacle whatsoever to them raising these arguments before the commission. They just chose not to. And I think there might be some close cases on what constitutes a reasonable ground, but this is not one of them.
What would be your case where you thought there would be reasonable grounds?
Yeah, so one reasonable ground case that comes to mind, I think if there's an intervening change in law, I think that might be a reasonable ground case. But there's nothing like that here. Lucia was decided while these proceedings were pending. Petitioners had no problem raising Kokesh when that came up and brought it to the commission's attention. Lucia was out there. They didn't say a word about Lucia. This is just something that they came up with for the first time on appeal, and I don't think this court should, encourage that type of practice.
So do you think the Freytag, I guess you spoke about this a little bit earlier, but you think Freytag is simply not applicable in a context where you have a mandatory or jurisdictional exhaustion statute?
Yeah, I just think it's a very different set of considerations there because we have a statutory exhaustion requirement. I mean, I will say that, the way that we read the case law, it seems like the court has backed away from what it did in Freytag a little bit. So in Lucia, it talked about appointments clauses, challenges being raised timely, and that cited Ryder, the Supreme Court's decision in Ryder, but it's a different set of considerations.
Here's a hypothetical for you. Suppose the SEC were to issue a rule that related to FINRA procedure. There wouldn't be any question in those circumstances that anybody affected by the rule, any organization affected by the rule, could bring an action in the Court of Appeals challenging the appointment process.
At FINRA?
In other words, I'm distinguishing a challenge to a rule from an adjudication.
Your Honor, I don't know how to answer that, frankly. I think that's, possible, and maybe the court would have to confront that in that circumstance. But in this adjudication, we do have very clear guidance from Congress. Congress wanted objections to be urged before the commission. They were not.
Well, you see, if it was a rule, you wouldn't have the same problem. But anyway, you don't have a rule, so that's just a hypothetical. Why? Well, I'll reserve a question for counsel on rebuttal. Go ahead. I'm sorry.
Judge Rao, did you have a question?
No.
Go ahead. Go ahead, counsel.
Oh, pardon me. I thought the court might have had a question. Well, unless there are any further questions, we'd ask the court to deny the petition for review and affirm the commission's order.
The argument about how to treat the continuing education expenses wasn't a valid exercise of business judgment?
Sure. And so, again, this argument, their only legal argument about liability on this was raised for the first time in the reply brief. The only thing they said about this in the opening brief was about disgorgement. But, I do want to give the court comfort on this issue. And this is addressed in the commission's opinion at JA 11. And, the bottom line is that their argument just doesn't jive with the contractual language or with the evidence. So the language in the offering documents is it authorizes the funds to be charged for such other related administrative expenses as are necessary for the prudent operation of the funds. So it's not just anything that petitioner considers prudent. It has to be necessary for the prudent operation of the funds. And the briefing on the other side just completely omits that necessary language. And then on the facts, recall what we're talking about here. These are FINRA continuing education expenses put on by Commonwealth Securities, which is the broker dealer. But petitioner wants to, she wants to charge investors for the cost of putting on that continuing education for employees of Commonwealth Capital, which is not the broker dealer. And there's just nothing in the record to explain why that's necessary for the prudent operation of the funds. The closest they come
Right, so
is
the education was for Commonwealth Capital, not Commonwealth Securities employees.
correct. I mean, that's the whole dispute. Yeah. And so, the closest that they come to is they cite petitioner's testimony at JA 676 that she used her business judgment, but there's just nothing to give content to with that to explain why she thought it was necessary for the Commonwealth Capital to get continuing education on FINRA requirements when Commonwealth Capital isn't the broker-dealer. They can't perform broker-dealer functions.
Right. My colleagues have any more questions?
No, ma'am.
All right. Thank you very much.
Thank you, Your Honors.
And we will give Mr. Dre 2 minutes for rebuttal.
Excellent. So
Before you start, counsel, let me ask this question. You can see at best, at very best, for your point of view on the appointments clause, including the officer of the United States question, your very best you could say at the time you're litigating this case and before the commission is there's some confusion on this issue coming from the Supreme Court. Arguably, PCOB is inconsistent with Elgin. 3 justices thought so. So, isn't it unreasonable not to raise this issue before the SEC?
No, and actually, I'm glad to get back to the reasonable grounds argument because it occurred to me while my friend on the other side was speaking that Judge Rao was asked about the mandatory statutory requirement here and whether that distinguishes the other cases. It does not, because as this court has explained, and we cited at page 6 in our reply brief.
You're not answering my question. My question, given the best you could make out of an argument is there's some confusion. I think Jarchese is very much against you. But the very best you could make as an argument is there's some confusion in the courts. And therefore, why isn't it unreasonable not to raise this issue before the Securities and Exchange Commission, given the fact that it is arguably a jurisdictional point?
So I disagree with Your Honor's premise about whether there's confusion on the relevant part of PCAOB for this case. And then as to the reasonable grounds, I call the court's attention to its precedent in the Washington Association for Television and Children case, which explains that 78 CY1 merely codifies the traditional common law exhaustion requirement. So in light of that,
isn't that case before KPM?
You're not answering my question. Why isn't it unreasonable not to raise this issue before the Securities and Exchange Commission?
It's not unreasonable because I don't agree with the premise that there is confusion about the meaning of PCAOB. Moreover, we're not obliged.
I'm not. Elgin backs off PCAOB. Isn't it clear?
No, Your Honor. But moreover, and more importantly, I think, a litigant is not obliged to raise these issues in front of the unconstitutionally comprised adjudicators. It can wait until it's in court. That's what happened in Freitag. Even after stipulating to appear before the special judge in that case, they waited until they were in the Fifth Circuit to raise the appointments clause issue. And the court at some length explains why that was the appropriate thing to do and why the court could still take it up. So I submit
I thought you were trying to ask a question a minute ago about the children's television case.
Well, again, for one thing, Freitag, again, there was no jurisdictional statute. In the case that you keep citing about interpreting 78YC1 is before, I believe, our decision in KPMG, which said that that statute was jurisdictional. So you can't really rely on that earlier case.
Well, so KPMG doesn't reverse on whether or not the purpose is mere codification of the common law preservation requirement. So
well, a common law preservation is different from a jurisdictional requirement. I mean, it may not say it's reversing, but I mean, those are two very different things. To say Congress created a jurisdictional exhaustion bar is different from judge-made exhaustion doctrines.
And perhaps the way to cut the knot, Your Honor, is to think about what exactly Congress made here. And that's where the reasonable ground does some of the work. And KPMG is actually very helpful for that because, as they explain, it's just a, quote, reasonable explanation, which I think is more than satisfied in this case. The one other thing that I would like to respond to briefly is about the continuing education expenses. The reason that those are appropriate, and we cite, it's a stipulated exhibit at JA 544 through 545 that lists the allowances for charging expenses to the funds. And I encourage the court to read it entirely because I think it's clear that it incorporates the business judgment rule. And the reason
the difficulty for us, of course, is that you didn't raise this argument at all until your reply brief. So we have no briefing from the SEC. I mean, he just gave us some response here to oral arguments. So why isn't that argument forfeited by failure to raise in your opening brief? Unless you can point to me where your opening brief raised this argument.
I will look for that, but it's everywhere that we talk about the Liu decision around disgorgement. And we explained in the opening brief that the Commonwealth Capital has no employees, the funds have no employees of their own. Commonwealth Capital has.
No, I've got that. We got that. I was talking about the record evidence argument you're making now about business judgment rule, which I did not see that phrase in your.
That is the argument that applies here, is that because the funds don't have any employees of their own.
That doesn't establish business judgment rule or necessity, like you said. But it's a whole I'm asking you a separate question. I'm not asking you to rehearse your argument on that front, which we have from your reply brief. What I'm asking you to do is say why we would even entertain it since it wasn't raised in the opening.
So here it is in the opening brief, page 11. We explain the operating agreements between Commonwealth Capital and the funds did not require any contribution to the salaries, but it did allow reimbursement for expenses that were in Ms. Springsteen-Abbott's business judgment, quote, related to the operation and administration of the funds. And it goes on.
That's not even the argument section of your brief, page 11.
At some length.
That's your background description of what you argued maybe below. Can you tell me where in your argument section?
No, that's background facts for the argument that appears, let me see, at page, okay, so then at page 5, you get the Commonwealth Capital operating arrangement explanation. Pages 7, 10, 11, 16, and here's the Liu citation is at page 53. This was absolutely raised in our brief, and the factual record.
All right, that's fine. I'll look again and see if you've raised this argument in your brief.
Great.
Do my colleagues have any further questions? We're way over. We've had a lot of time at this point. Do my colleagues?
Yes, unless there is anything further, I'm happy to leave everything else on the papers.
Mm-hmm. Thank you. Thank you both, counsel. The case is submitted.
Take your mask off.
Are you waiting for the next case?
Yes.
Case number 20-5024, Paul S. Morrissey, appellant, versus Chad F. Wolf, acting secretary, U.S. Department of Homeland Security, and case number 20-5042, Kelly Stephenson, appellant, versus Elaine Chao, secretary, Department of Transportation. Mr. Lyonsburg for the appellant, Kelly Stephenson, Mr. Tutt for the appellant, Paul S. Morrissey, Mr. Glover for the appellee.
May I proceed?
May it please the court. I, along with my colleague, represent the appellants in this case. With this court's permission, we will divide our time as follows. I will be arguing the issues that are dispositive for both cases for 9 minutes. My colleague will argue the issues individual for each case for 3 minutes, and I would like to reserve 3 minutes for rebuttal. This court should reverse both district court dismissals below for 3 reasons. First, a heightened standard should apply to dismissals without prejudice, where the statute of limitations would bar refiling of those claims. Second, the district courts below did not apply the relevant equitable factors, even under a lesser standard, to dismiss these claims. And third, because neither plaintiff below waived or forfeited any arguments. A dismissal that permanently ends a lawsuit, however styled, is effectively a dismissal with prejudice. This court should apply the Milan standard articulated by the Fifth Circuit and hold that a court can only dismiss a case for a failure to serve where the statute of limitations would bar refiling when there has been a clear record of delay or consummation conduct. This court already applies such a standard to motions to dismiss for failure to prosecute under Rule 41B and has applied this standard to a case where the failure to prosecute was a failure to serve the defendant in that case, and that was the Angelino case.
Isn't that a case where the marshals, is that the one where the marshals screwed up?
No, Your Honor. This is the case where the defendant was a foreign government and the plaintiff in that case failed to serve the foreign government over an extended period of time.
But wasn't there a problem with respect to the service? It wasn't the plaintiff's fault?
Yes, Your Honor, that is correct. In that case,
that's hardly authority for your position here. There's a stray word, a couple of words that you rely on, but the fact of the matter is the plaintiff was not at fault at all.
In that case, yes, Your Honor, that is true. But the principle articulated by this court is the same, and that is a dismissal in that case would only be appropriate if there was no reasonable possibility that the plaintiff could obtain service.
That is not the holding of the case. One of the things that drives me a little wild is that modern education teaches lawyers to find a sentence that looks good and assert it at the holding of the case. That's not the holding.
Yes, Your Honor. The holding in that case was that when there was, in that case, because there's dismissal under failure to prosecute because the sovereign defendant refused to accept service, and the plaintiff had other possibilities under different subsects of the rules for serving foreign sovereign governments, they should be allowed to try that before dismissing the case for failure to prosecute there.
But the point was, it wasn't the plaintiff's fault.
Yes, Your Honor, that is correct. And we freely admit that both lawyers below made a mistake in failing to properly serve the government in both of these cases.
What about Barreau? Barreau versus the Embassy of Zambia. That case involved misservice efforts by the attorney, correct?
Yes, Your Honor.
And what test did we apply there in evaluating whether the case should be dismissed?
Your Honor, I have to refresh myself on that case.
I think we said that dismissal is not appropriate. A sua sponte dismissal is not appropriate if there exists a reasonable prospect that service can be obtained.
Yes, Your Honor. And that is the test that we believe should apply here, where a dismissal would be with prejudice.
So that our precedent is held even when it's attorney negligence.
Yes, Your Honor.
Okay, but that's not the heightened standard you're arguing for. You don't need that heightened standard. You just need us to apply Barreau.
Yes, Your Honor. If this court applies that the only reasonable grounds for dismissal would be if service cannot reasonably obtained, then both of these cases could be reversed on that ground.
Is Barreau a case arising under Rule 4M?
I believe so, Your Honor.
Or is it arising under the FSIA?
It could be under the FSIA, Your Honor. In that case, I believe that was the case where the marshal
Well, you
refused.
just said we should apply that test, so I think we should know whether it's under, you should know which statute it's under.
Your Honor, I said you could apply that test, and it would resolve both of these cases.
What were the, review the facts of that case in terms of service. What was the problem?
I believe in that case, the plaintiff filed with the marshal to deliver service on the foreign defendant in that case, and the marshal refused to deliver the service because the marshal believed that the defendant would not accept service in that case, and the lawyer in that case failed to properly serve the defendant.
Yes, but wasn't that the marshal's problem? Wasn't it? You say it was the plaintiff's fault. It's not clear that it wasn't the marshal's fault.
Well, Your Honor, in that case, the plaintiff could have had other avenues to serve the defendant and chose to utilize the marshal service. And so in that sense, that would be the plaintiff's attorney's responsibility to properly serve the defendants.
Perhaps, but it seems to me distinguishable from the case here today.
Well, Your Honor, we believe the best rules articulated by the Fifth Circuit in Milan. And the Fifth...
Yes, Mr. Weinsberg, though, what about our precedent in Mann, which says that good cause to extend time for service exists if there is, good cause only exists if there is some outside factor rather than inadvertence or negligence?
Yes, Your Honor.
What is the outside factor here that explains the repeated failure to properly effectuate service under the rules?
Well, for Mr. Stephenson's case, we do not believe that there was good cause for failure to serve. For Mr. Morrissey's case, we believe that the complexity of Rule 4I and the fact that the plaintiff in that case timely served the agency, although not the United States Attorney or the Attorney General, constituted good cause in that case.
What is complex about the rule?
I think that was exactly the question I wanted to ask.
Yes, Your Honors. Under Rule 4M, normally, all a plaintiff must do is serve one defendant, the person they are suing. Under Rule 4I, the plaintiff, when suing the United States government, must sue three people: the agency being sued, the United States Attorney for the district in which they're bringing suit, and the Attorney General. As the committee notes for the Federal Rules of Civil Procedure recognized, these rules are much more complex than the rules for normal service.
4M applies to all the different forms of service under Rule 4. It's just the time for service. It doesn't just apply to the... I thought you just said that applies when you're serving one person. 4M covers all the different forms of service, including foreign governments and the United States and routine service.
Yes, you are correct, My Honor. I misspoke. I meant to say in a normal case, the rules require only serving one individual. And the United States government is a special case because it requires serving three individuals. And the committee for the federal rules stated that the rules should be interpreted leniently to prevent a plaintiff from losing their substantive rights due to the difficulties of serving the United States government.
What is the difficulty, though? I mean, you just articulated what the rule was in about 10 seconds, right? I mean, I'm not sure how that's complex. Like, there are additional requirements when you serve the United States, but it doesn't seem to be either ambiguous or complex. It's just additional requirements.
But we certainly agree that it is not difficult. However, it is complex in the fact that you have to identify and serve three separate individuals. And
that doesn't make it complex. It's crystal clear what you have to do. I can't imagine any lawyer reading that and getting it wrong if that lawyer was admitted to the bar.
Your Honor, we are certainly not excusing the lawyers below failure to properly serve the United States government, but
no,
it was recognized.
You're suggesting it's complex, and I agree with my colleague. I don't see it as complex at all.
Yes, Your Honor. and that is reasonable. The committee notes to that rule, however, do identify the rule as complicated and that it may be difficult for some plaintiffs to timely serve the federal government. However, our argument does not rest on whether...
It happens with some frequency, correct?
Yes, Your Honor, it does.
That's why there's exceptions in Rule 4I for when you get when you miss one of them.
Your Honor, the exception under Rule I provides for a mandatory extension when you serve either the United States Attorney or the Attorney General.
So the rule itself seems to assume that there's going to be risk of people missing one of them.
Yes, Your Honor. Yes, Your Honor.
And then the advisory committee notes for 4M, which is the timing issue, point to that as an example of the need for flexibility in granting extensions.
Yes, Your Honor, they do. And we believe that flexibility would be warranted here.
But why? As my colleagues have pointed out, the problem here is really just lawyers who didn't do their job. You give us your best argument as to why the concerns about the reasonable prospect of service should apply in this situation.
Well, yes, Your Honor. We believe the punishment meted out by the district courts in this case does not fit the crime. In a normal case where a case is dismissed under Rule 4M for failure to serve, the sanction is essentially the cost of refiling the case. It is a judicial slap on the wrist. The plaintiff has to refile their case, repay the filing fee, and restart the process. Here, and by contrast, the sanction was the death penalty for these plaintiffs.
Let me go back. Excuse me, counsel. Let me go back. Would you concede that it's almost res ipsa loquitur as a negligence on the part of lawyers in these two cases?
Yes, Your Honor, we would concede that the lawyers below did not act as they should have in serving the federal government within...
No, I'm asking a question on its face. Doesn't it look like negligence?
Your Honor, it does.
Okay, thank you.
Yes, Your Honor. However, we believe...
Does that mean then that the individuals in both cases may well have a remedy?
Your Honor, it cannot be the case that the federal rules remedy for a procedural mistake is for plaintiffs to sue their own attorneys for malpractice.
Why?
Well, Your Honor, because the very first federal rule states that all federal rules should be interpreted in a way to provide for the just, speedy, and inexpensive resolution of cases. And
so that's designed to protect lawyers?
Your Honor, that is designed to protect litigants.
Yes, so if the litigants have a right of action here, presumably, then it's not such a drastic remedy at all, is it?
Well, Your Honor, if the only interest was these plaintiffs receiving remuneration for their discrimination by the government, then that may well be the case. However, both of these plaintiffs have an interest in airing their case in court, in being heard, and in hopefully holding the government responsible for that discrimination. It is not purely remunerative benefits that come from a plaintiff bringing their case in federal court. There are also other benefits of having their issues heard, of having their day in court that would be deprived if plaintiffs were forced to litigate against their attorneys for malpractice.
Wouldn't be hard litigation.
Perhaps not, Your Honor, but it would not fulfill these plaintiffs' desire to have their day in court and to have their cases heard.
Mr. Lyonsberg, let me ask you another question. So in these cases, the plaintiffs are able to sue the government because the government has waived its sovereign immunity under the relevant statutes.
Yes, Your Honor.
So why, I mean, are these procedural rules, should we read the Federal Rules of Civil Procedure to also be part of that waiver of sovereign immunity, right? Therefore, the government allows itself to be sued, but only when people, only when plaintiffs comply with these rules.
Well, Your Honor, when Congress passed that statute allowing plaintiffs to sue after going through the EEOC process, they adopted the background rules of federal litigation. There is no indication in that statute that Congress intended for an especially strict interpretation of the federal rules to apply simply because they were the subject of the lawsuit.
Well, I mean, it's just though it is part of, I mean, if that is though, I mean, it is a rule that's passed by Congress, right? And it is the way that plaintiffs have to serve the government.
Well, Your Honor, service of the government is in the. Please continue.
I mean, you know, it could be that the government says, you know, we need this type of notice in order to properly protect our rights, you know, when we have waived our sovereign immunity to be sued.
Well, Your Honor, if Congress had intended for that interpretation to apply, they are perfectly capable of including that in the statute that creates the right of action, the cause of action to begin with. By being silent on the issue of what rules should govern the litigation once plaintiffs make their way into federal court, Congress presumably.
Well, they're not silent. They have the rules of civil procedure.
Didn't the Supreme Court say in Irwin versus Department of Veterans Affairs that once the United States waives sovereign immunity, it's subject to the same principles on timing, statutes of limitations and timing, and exceptions to statutes of limitations like equitable tolling as all the other parties?
Yes, Your Honor. Okay. And that is another reason that once plaintiffs make their way into court based on the EEOC right to sue letter, they are governed by the same rules as all other litigants. The Congress has already created a harsh penalty for failure to timely act on their rights, because after going through the EEOC process, plaintiffs are given a 90-day right to sue letter. So they must bring their suit in federal court within 90 days of receipt of that letter, or their claims are permanently barred.
Okay, do my colleagues have, you're over time here, Mr. Leinsberg. Do my colleagues have more questions for you?
No.
Okay, I think we'll hear from Mr. Tutt now.
Thank you, Your Honor.
Thank you, Your Honor. May it please the court. I am only going to take 3 minutes. I join my colleague in saying that this court has a very clear path to reversal, just to apply the heightened Milan standard already applied in the Fifth Circuit to avoid opening a circuit split with the Fifth Circuit on that issue, and because it's the appropriate standard to apply in cases like this one involving a minor breach of the federal rules that can be easily remedied by a short extension of time. I am going to be addressing issues unique to the two cases, grounds for reversal in the Morrissey case and grounds for reversal in the Stephenson case that are separate and apart from the common questions. In Morrissey, there are two grounds to reverse. First, that there was good cause to extend time in the Morrissey case, and second, that the court abused its discretion as a matter of law because the court drew an adverse inference from the existence of Rule 4I4 that was legally erroneous and therefore a abuse of discretion by definition.
Can we start with that latter point about the error of law, please?
Yes, Your Honor. Yes. So Rule 4I4, which I think, to Judge Rao's question, is further evidence that that Congress actually wants to keep these cases in court, says that when partial service is affected under Rule 4I2, because the Attorney General has been served or the U.S. Attorney has been served, all other parties who you are given a mandatory extension of time to serve all other parties that must be served. The court held that because this case doesn't fit that profile, because he had served the named defendant rather than the U.S. Attorney or the Attorney General, because he wasn't entitled to come under that mandatory extension, that actually weighed against a discretionary extension.
Actually, aren't you overstating what the district judge said?
I don't think I am. The court said.
What was his exact words? Didn't he just make an observation?
He said that he does not come within the four corners of Rule 4I2, but then he said, and I want to quote, it's very close to a quote, further weighing against a discretionary extension here.
What is his exact words?
I'm afraid I am operating under COVID
Well, I'll read it to you.
I apologize. Thank you,
I'll
Your
read
Honor.
it to you. I will read it for you on A34. The choice to provide relief for some instances of partial compliance with Rule 4I, but not with the instance of partial compliance we have here, is yet another factor that counsels against an extension of time.
Thank you,
Right?
Judge
The rule
Millett.
provides for some relief from the complex requirements of Rule 5, but they do not contemplate relief in this case. That's what's said on A34.
So he said it was a factor, counseling.
Yes, Your Honor. And so we think that he put some weight on that his conclusion to some extent, however minor, relied on that, and that because that's a legal error, you would have to at minimum send it back and allow him to reweigh it with a appropriate understanding of the rule of 4I4.
How is that a legal error?
Your Honor,
I guess I just don't understand why it would be a legal error to read the rule that way. As like
Your
one
Honor,
factor.
that is, Your Honor, we think that the rule is absolutely clear, and especially read in conjunction with the advisory committee notes to the rule, that 4I4 should not be read as to draw a negative inference. Just at a basic level, it means that if he hadn't done anything at all to serve the government, he would have been in a better position because there would be no factor to weigh against him for failing to come within 4I4. So it would mean that if you actually do what Mr. Morrissey did here, which is actually get halfway there, you're in a worse position than a litigant who does nothing.
I think you're slicing the salami pretty thin to call it a legal error.
Your Honor, his opinion, the court below's opinion is very short and only looks at a small number of equitable factors, meaning that this particular salami, though thin, has an outsized weight on the scale because the only other factors that the court considered were that he had an attorney and that he had made partial service. I'm blanking on the other factor at the moment, but I'd like to turn to Mr. Stephenson. I think he has another ground for relief here too that's unique to him, which is that if you look, and this is very straightforward, if you look at the December 5th minute order the court issued dismissing his case, the court says that he is required to dismiss the case for failure to effect timely, complete service, and makes no mention of any consideration of his discretion to give an extension. So the minute order shows no evidence that the judge believed that he had discretion to provide an extension. And on the motion to reconsideration, if you look at it, the district court takes the view that an extension should have been sought in advance, and that the failure to seek an extension in advance is a reason for denying any further discretionary extensions. So further showing that the court is actually conflating two distinct concepts, which would be the court always has discretion to extend deadlines except in very limited circumstances when asked in advance. But Rule 4M envisions that courts will give notice and give litigants an opportunity to make service if the grounds for a discretionary extension are met. And I have nothing further. If the court has no further questions.
My colleagues have any further questions?
No questions.
All right. Thank you, Mr. Tutt. We'll hear from the
Thank you.
government now.
Good morning, and may it please the court. I'm Matthew Glover, and I represent the government in both of these cases. In these cases, the district courts at every step of the way considered the facts that were in front of them, applied the appropriate legal test, and ultimately dismissed the cases and denied motions to reopen and for rehearing. These cases are a result, as Mr. Lyons-Burke conceded, of foot faults by plaintiffs' lawyers below. And now on appeal, they're raising new arguments seeking to do away with or erase the foot faults. And we think in the abusive discretion standard, the district courts looked at the factors that were presented to them, looked at this court's, in Morrissey in particular, looked at this court's opinion in Mann and the factors described there, and reached an appropriate conclusion.
Why should there be a different standard for dismissal based on attorney negligence in a service context than there is in the failure to prosecute context, including failure to prosecute by service.
Your Honor, I apologize. And maybe my speaker, you cut out there. You said in a different context, and then I lost you for about 5 or 6 seconds.
Sorry about that. So
I've turned the volume up, though.
I apologize. That should be working. Why should there be a different standard, just in the context of attorney negligence here, for dismissing a case out of hand based on attorney negligence rather than merits, when it's a service failure rather than a failure to prosecute, where we definitely require more?
So a couple of points to that, Your Honor. Failure to prosecute is always a dismissal on the merits. And so, to invoke that rule, you need to have actions in which you're acting on the merits, and failure to prosecute dismissal is a sanction. Rule 4M contemplates that if you fail to provide service within 90 days, the court shall, and then it provides two options.
No, but I'm talking, I should have been clearer. I'm talking here about the case, subset of cases where this is the end of, there will be no merits, where there is no time to refile. I apologize. But in this situation, that seems like a pretty weighty factor in my view. And why should we allow attorneys to mess up and be negligent and non-responsive for months, if not years, for a failure to prosecute, but not for a few weeks on service?
So I would make 2 points to that, Your Honor. One is when you hire your attorney, you're tied to, the actions your attorney acting on your behalf and making mistakes. That's the same in a failure to prosecute. I agree. But my second point would be failure to prosecute is a sanction. Here, you're always going to be able to say, give me more time, I could serve. I don't know what a lesser sanction would be. The failure to prosecute—
lesser sanction would be a fine. In order to show cause, a fine?
So Rule 4M doesn't necessarily contemplate, at least I don't read it to contemplate anything other than a dismissal or providing reasonable time for service. I suppose you could say you
is it
the
United States government's position that those are the only two options?
I'm not saying that they're absolutely the only two options. I'm saying the rule says that you shall either dismiss or provide a reasonable time.
Sure, but courts always have the authority to sanction attorneys who are misbehaving.
That may be the case,
that may
Your
be.
Honor.
We don't. There are times we don't have.
Your Honor, I confess I'm not sure. I haven't looked at district court rules with regard to sort of what process is required for a monetary sanction or something like that. I'm not saying that they don't have those equitable authorities. I just couldn't delineate what the test is for when you would apply or what process you might be due before a monetary sanction. But on this, I would also— I apologize, did I interrupt you?
No.
Oh, okay. I would also point out that they did not argue below for this heightened standard, and we think this fits clearly and similarly to GSS Group.
Okay, but I'm putting aside the heightened standard. I'm looking at, we have an awful lot of cases involving all different forms of attorney negligence, including failure to prosecute by service, where we have required a higher showing before we dismiss, at least when we know that that's going to be the end of the case. And I'm just having trouble understanding why, particularly in Mr. Morrissey's case, where there wasn't even one extension of time.
Your Honor, I understand. And if I could step back for a second and make clear, the government's position is not that it would have been unreasonable for the district court to have given an extension in either of these cases. In the abuse of discretion standard, there's obviously a broad range of action.
Your position that is that it's perfectly reasonable for them not to. Can you cite me another case anywhere where there has been a dismissal of a case that will end that case? It cannot be refiled without either a single extension or an order to show cause for the attorney to explain what's going on? Can you cite a single case?
Yes, I would point to the Colasante versus Wells Fargo that's cited in our brief. It's out of the Eighth Circuit. If I could walk through the facts there briefly, it was under the same rule, but when the period was 120 days. The plaintiff there, I believe, was in the Southern District of Iowa. It was in the Iowa District Court. The plaintiff was needing to serve Wells Fargo at its headquarters in San Francisco. On the 118th day, the attorney contracted a process server. The process server didn't manage to serve Wells Fargo till the 121st day. Now, that was not a notice and dismissal. Wells Fargo moved to dismiss state law claims on a different ground and the federal claims on the ground of a failure to effect service in the 120-day period. The district court there considered the statute of limitations among other factors and decided that the fact that they had waited till the 118th day to seek out a process server, and the attorney explained that his client had moved, and the district court said, well, you didn't make an effort to, stay in contact with your—
That sounds like a case where they had a full opportunity to brief the issue to the court.
They had a full opportunity
before there was a dismissal. And I was asking for a situation where there's not even an order to show cause or an extension, just an immediate dismissal.
So cases that I have found where you have this sort of notice, as we had in Morrissey, and then you have a dismissal that follows purely on the docket, typically there hasn't been a response. And so you didn't take the time to explain.
Right, so you have some other cases where there's been a docket entry before the time has even run. And then when the time runs, a prompt dismissal without an order to show cause. Or, I mean, in Mr. Stephenson's case, the court gave a couple weeks and then issued an order explaining what should happen and gave on its own motion or its own decision a couple more weeks. And Mr. Morrissey's case is quite starkly different in that regard.
So I would make 2 points to that, Your Honor. The first is that there are a number of instances where the district court gives the notice or the reminder saying, please effect service by the deadline in advance. I'm not going to say that I found a case in which the dismissal was on the 94th day. I found some where
I'm sorry, finish your sentence. I apologize.
I found some where the dismissal, there was a show cause in advance. There was a discretionary extension of, I think, 14 days, and then the dismissal on the 113th day out of California. And I found one.
I'm just saying this, do you have one that's like this, where there's no discretionary extension at all or an order to show cause?
So I think no, I don't have a case on all fours with
this
that.
Would be the first case that has ever done that you could find, or I could find, or the council could find.
True. I would make just one point on that, though. As Mr. Tuck points out in the Morrissey reply brief, the U.S. reports clearly don't have that, and the U.S. reports are going to be searchable when you have the scenario we're talking about. And in Morrissey, they were initial minute order, although the second order was not a minute order. Those don't tend to have been picked up. You can search dockets.
You represent the United States government. We're talking about the unique service obligations for the government. I assume you're not aware.
No. My only
point was, have any colleagues who were aware as you were preparing this case?
No, I spoke with colleagues. My only point was going to be it's much tougher to search dockets, and I did attempt Lexis docket searches and found some dismissals on 113th and 116th day, but the Lexis docket searches tend to be only the past few years, and there isn't a pacer for the Court of Appeals. You can search by month for orders, and for the district courts, you can't search orders. At least I searched about 10 or looked at 10 web pages, and I didn't see any that had that option. And also with the Lexis dockets, they tend to be just the past few years of Lexis dockets. So, for example, some of these older cases, I wasn't even able to find the district court docket for some of the cases in the 90s that we cite in the briefs. Or the Court of Appeals dockets. I was only able to find the one Westlaw opinion.
Right. No, I appreciate your diligence. You clearly have been very diligent, and I think we're still left at the same position where I started. And there's never been a case like Mr. Morrissey's.
So
that we can find. None of us can say for sure.
I think Dixon, which we cited.
Is there any case going the other way?
I'm not aware of one. I would point Judge.
You're not aware of cases where there's been either an order to show cause or extension by the court? I think Mr. Stephenson would be a case that is done otherwise.
I took Judge Silberman to ask about a case in which there, had not been an order to show cause and not an initial extension, and it was appealed, and that was the sole grounds for giving another chance on appeal. I apologize. I took him to mean a holding of the Court of Appeals sending the scenario you were asking me about in the district court back. Given that I haven't found that scenario, I don't have a case sending one back. I think Dixon.
You don't have a case. You don't have a case either way in this situation, do you?
No, I think, and I'll venture, and I apologize, I don't want to conflate Dixon and Richard versus Steverson. Dixon, which we quoted, Westlaw has available the district court's one paragraph order, and then it has available this court's summary affirmance there. And I don't recall if I was able to get, I think it's from about 2002, the district court docket, but the dismissal was one paragraph, and it mentioned that an affidavit had been filed after the notice, but the affidavit didn't explain how they had served the United States. It was a case under, I believe, what was then still Rule 4I after it had moved from 4D for serving the United States.
Do you agree with me that the prior cases for failure to prosecute, in which the court was more merciful to the plaintiff, all involved cases in which the marshals or some other factor caused the difficulty in service?
Yes, Your Honor. And if I could comment quickly on, and I'm not sure how the first name is pronounced, or the last name, but Barot or Barat versus Embassy of Zambia. It wasn't cited in the brief, so I only have the slip copy with me, but I've looked at the slip copy during plaintiff's argument. From page 3 to 4, the court describes, as Judge Rao noted, that was under service under the Foreign Sovereign Immunities Act, and it describes that the court has a central role to play there. And I think it's slip 3 to 4. It mentions how the marshal, which is who the court is ordering to serve, served the Embassy of Zambia in DC, but you were supposed to serve, I think, the Foreign Affairs Ministry or their equivalent in Lusaka, the capital of Zambia, I believe is Lusaka. And so there was an error by the court there, which Judge Silberman, that's the sort of mistake you're describing. So I don't think that case is
look at Roman 2 of that opinion. All right. And now it's saying, in general, district courts have broad discretion to dismiss a complaint for failure to effect service. That's not talking about the FSIA. I think that would apply generally. The court has cautioned, however, in cases of sua sponte dismissals for inadequate service, dismissal is not appropriate when there exists a reasonable prospect for that service can be obtained. There's nothing about the language that's confined to the FSIA context, and both, Rule 4 was also raised in the briefing in that case. And then the discussion after that is not about the court's failure, it's about Barot's latest service attempt, and he got something wrong. But they thought there was a reasonable prospect. So it's just the Roman 2 portion here seems to stand separately.
Your Honor, I would point in Roman 2 to directly after the citation to the string cite of Angelino and then Peterson, because of the district court's statutory responsibilities and prominent role in the mistakes of service in Barot's case, the prejudice. So that was a factor. It was the first factor the court described. And I would just step back and say, when you have a situation like Colasante, where they served on the 121st day, the other party can come in and file a motion to dismiss, and that allows you to dispute the motion to dismiss, but it doesn't give you sort of an extended period of time or notice after the deadline that you get more time to serve. So
what the court there is citing for its rule, Peterson versus Archstone communities. That's not a foreign service case, foreign sovereign case. That's actually an age discrimination case. It would apply in the lack of prosecution standard that I've referenced, citing that to support a service rule. So I don't think this is confined to foreign service here, this language.
Understood. Sorry.
Would you agree with my colleague that the court announced a rule, or would you say it was an adjudication in which the holding depends on the facts of the case rather than a statement?
Judge Silberman, I would agree with, I apologize, Judge Millett. Were you?
Oh, I was coughing. Go ahead.
Oh, I'm sorry. Judge Silberman, I would agree with you that it was an adjudication in which the court was describing, and the factors that I began with, I know that I'm over time, if I can proceed.
Go ahead, please.
The court was evaluating factors there, the first of which was the district court's prominent role. And if I can step back and say this is a rule context, and so there has to be some scenario in which when, as the Seventh Circuit described in Tuke, when a rule has a deadline, missing it by even one day can be fatal. And so here we think the district courts provided the required notice. They waited for a response. The purpose of the notice, if I can actually step back and point to a case that Mr. Stephenson cites at page 36, I believe, of his reply, it's Ruiz Vela. It's a First Circuit case. Just a second. In Ruiz Varela, the First Circuit held that you could not provide notice, dismiss, and then allow them to file a Rule 59E, and that although Rule 4M contemplated notice before a sua sponte dismissal, that was okay so long as you provided this after dismissal opportunity to contest. It followed a Ninth Circuit case from the prior year, 1986, called Whale. This court did not adopt that standard in a pro se case called Smith Bay versus Kripe at 852 F. 2nd 952. This court there said, given the pro se nature of the individual, we think that the notice required in 4M is notice before you dismiss. And so we're not adopting this standard where you can dismiss and then, give an opportunity afterwards. In both of these cases, they gave notice beforehand. And in Dixon, which again was a summary affirmance by this court of a one paragraph dismissal, the court cited Smith Bay for the proposition that the standard for Rule 4M was very clear. And if I could just make one more comment on Dixon. I know that Mr. Stephenson has made arguments that because the minute order doesn't describe having, the discretion in both Dixon and Steverson, the district court orders, which I think were one paragraph, and then, and this is dismissed in the next sentence. So maybe that counts as two paragraphs. Neither described a discretionary extension. And the argument that the district court needs to state is that it's not exercising its discretion in its order was raised by court-appointed amicus at page 45 of their brief in Rashad versus Steverson. And this court did not accept that argument then. And if I could make one
Mr.
additional...
Robert, can I ask you a question? Are you aware of cases in which this court has found it was an abuse of discretion for the district court not to exercise its discretion the way other district courts may have done so in the past?
I'm not aware of any in terms of the discretionary extension, sort of
right.
where you
So
have
if we
a double layer
agree
of
that
discretion.
the authority here is discretionary, do we have to judge whether it's an abuse of discretion based on how other judges may have exercised their discretion in the past?
I don't think so. I would just say that we cited Oklahoma Aeronautics for the point that the abuse of discretion is very flexible. And we cited a couple cases after that, and I can't recall the other names, but one described that abuse of discretion is when there's a standard of options that a court could act. And I tried to make this point in my opening that, the district court has a range of things that it can do. And we believe in both of these cases, the way that it acted was within that range. If I could make one point, I know I'm in the red light and I shouldn't be raising new issues, but just to respond to the Rule 4I discussion that the court had with my friend, Mr. Tutt, the court considered the fact that the rule did allow for an extension there as one factor. It didn't say that it was a legal test. It was weighing it as a factor. And in Mann, when this court described the factors, including statute of limitations in Mann, that were being weighed in the declining to give a discretionary extension, the court described the requirement that the district court make a clear error in its findings about how to weigh those factors. And so I don't think it's a legal error to have considered the structure of the statute, say the structure of the statute does provide automatic extensions in some cases. It doesn't provide them in this case. That's to say that there must be some case in which you haven't served the Attorney General and the U.S. Attorney in which you could dismiss. And I'll close just to pick up on a point that Judge Rao made in the opening, that the triple service here is important to the United States because under 28 USC 516, the Department of Justice is the only body, except where otherwise provided by statute, that can go into court and represent federal entities. And so serving the Attorney General allows for national consistent management of litigation. Serving the local U.S. Attorney allows for serving the department's office that's going to be closest to the court, have most familiar with the local rules, and it ensures that cases don't fall through the cracks when the government's a very frequent defendant.
Mr. Glover, do you think that those procedural requirements are part of the waiver of sovereign immunity by the government?
I confess, Judge Rao, I had not thought of that, and I hesitate to take a position on behalf of the United States for fear someone upstream of me in the department's authority would have views on it. I am aware of Irwin's discussion that Judge Millett mentioned about equitable tolling. I'm not sure if that would incorporate also Rule 4M.
Though for statute of limitations is different than service of process, right? Which goes both to this court's jurisdiction and might go to the waiver of sovereign immunity.
Yes, Your Honor. Again, I'm not sure, and I haven't thought it through enough to take a point or to sort of take a position on that. If the court would like more briefing, I can certainly, think more about that, and the government can present a position on that if it's important to the court.
I just thought it was an interesting point, and well,
I agree, but I apologize. It had not occurred to me.
For an aspect of sovereign immunity, then what discretion would the courts have in Rule 4I cases?
well, they have the discretion that's given in the rule.
Yes, and I suppose that
Well,
includes
isn't that
giving.
what we're talking about here? We're trying to figure out what the discretion in the rule is.
Yes. Yeah.
All right.
I guess my point is that it might go to how we think of whether something is an abuse of discretion if the rule in part is designed to protect the sovereign interests of the United States.
Yeah.
Mr. Glover, did you have, I'm sorry, Judge Rao, are you done? Are you done, Judge Rao?
Yes, thank you.
Do you guys have more questions? Or Mr. Glover, did we interrupt your sum up point or anything?
No, you did not. Oh,
Excuse me, I have no questions.
Okay.
no, you did not, Your Honor. I know I'm well into the red light, so thank you for the court's time. And if the court has no further questions, the government would ask you to affirm in both cases.
Okay. All right, thank you. Then I think we'll just have to give only one of you is doing rebuttal, is that correct on the appellant side?
Yes, Your Honor, I am.
Then we'll give you 2 minutes.
Thank you, Your Honor. I would just like to make 3 brief points on rebuttal. The first point I would like to make is that the government below did not contest that a heightened standard would be appropriate in these cases where dismissal without prejudice would permanently bar a plaintiff from refiling their case. The second point I would like to make is that the cases in this circuit make clear that it is the policy of this circuit to keep cases in court, if at all possible. And I would like to quote this court from English-speaking Union, that where dismissal on procedural grounds would be the death knell of a lawsuit, and that dismissal should only be used as a last resort. We submit that the district courts here use that as a first resort, not as a last resort in these 2 cases. And finally, I would like to mention the fact that to Judge Rao's point and to the point of protecting the government's sovereign interest, there is no finding of prejudice here. The government does not contend on appeal that there would be any prejudice from continuing these cases. And it is the stated purpose of the federal rules and the committee notes for Rule 4 that cases against the government should not be dismissed when it would result in the loss of substantive rights to the plaintiff. And that is what happened to both plaintiffs here. Thank you.
Do my colleagues have any further questions?
No further questions.
Okay. Thank you very much. The case is submitted.
This honorable court is now adjourned until Wednesday, December 2nd at 9:30 a.m.